Hello, my name is Geneva Perry. I'm founder and attorney at Promise Law. I was asked a question recently in a workshop, which is, can you all prepare a deed so that I can gift my house to my daughter? As I told the mom who was in that workshop, of course we can. We prepare deeds all the time as part of people's comprehensive estate planning. But the better question really is, should you? And the counseling question from our perspective when we meet with clients is, why do you want to do this and what are you trying to accomplish? In this case, the mom wanted to gift the house to her daughter to protect it from the mom's creditors. Essentially, she didn't want it in her name anymore. She wanted to protect from general creditors, and she also was hoping to protect the asset in the event she needed Medicaid long-term care. So she had several goals, and also to make sure it went to her daughter at her passing. But I wanted to share with you some of the information I said would be shared with her when she met with an attorney, which she absolutely needed to do before taking any action. First of all, if you transfer an asset to someone, even if they have really good intentions, something could happen that could get in the way of them being able to give it back to you, or even them keeping it. Take, for example, transferring it to her daughter. What happens if her daughter's in a car accident and is sued? Then whatever's been left might go away. Or maybe the daughter has a big medical emergency herself and has a lot of medical bills, has a bankruptcy. Or what if she has a divorce? All of these things might impact the asset eventually going to her daughter. And it certainly isn't there if she expects the daughter to help her out as needed. The other issue, of course, is that Medicaid will look at all transfers 5 years prior to application. So if this mom needs help anytime in the next few years, she'd be in really big trouble. She'd have transferred this house but not have it back. And what if all these things had happened and her daughter really couldn't do anything? Well, she'd be, as we say, up a creek. So that really isn't a useful solution. There are some other issues too related to these transfers. The mom didn't ask about this, but oftentimes people don't know that there are other issues that come up with what they think are the quick solutions to things. One is that there are some tax consequences to transferring assets to people. Two types, both gift and income tax. We'll take the gift tax first. Under the current tax law, you can give $15,000 per person per year. Over that, you need to use some of your estate tax exemption amount. Now granted, it's very high right now, about $11.58 million, so most people don't wind up ever having to pay tax, but you are required to fill out and complete and send in your return saying, hey IRS, I gave more than $15,000 away to a person this year. And that's whether it's cash or its equivalent, such as with real estate. The other issue is, depending on when the mom bought the house, she could have bought it for a lot less than it's worth now. So when things get higher and higher in value, there can be capital gains tax issues. If she transfers this to her daughter and her daughter later sells it, she might pay more tax than she would need to on the income tax side. But if an asset is transferred at death, it steps up to the date of death value. So essentially it can then be sold by the beneficiary and there's no tax paid. So there are lots of other reasons to maybe not go through with what she suggested. And moreover, there are other options. We prepare asset protection trusts that allow our clients to transfer in important assets, but they want to keep them protected. In these specialized trusts, the client can continue to be the trustee. Their son, daughter, whoever the beneficiary is, can be the beneficiary of the house at their passing or any other asset they've put in there. But importantly, because of the structure of the trust, it's not susceptible to either the clients nor their child's or other beneficiaries' creditors. So that is accomplished through this trust. Moreover, if you get past 5 years after funding it, any asset in the trust is not considered available under current Medicaid rules. So, can we do something? Sure. Should you do it? A better question. If you're wondering about your own estate planning, Medicaid long-term care planning, give us a call, 690-2470, or register for a workshop to learn more. We're happy to help.